All right, so today we will be talking about substantive patent law. Today's lecture is the patent law deep dive, right? So we're going to talk about aspects of patent law that maybe you covered a little bit in some of the topic lectures, but we're going to go a lot more in depth about how the patent law system operates, what the requirements for patentability are, how infringement works, how patent infringement ends up getting enforced by the courts when a lawsuit happens, and a little bit about remedies. So we're going to talk largely about statutory law that has been interpreted by cases. So as I mentioned in my earlier lecture, patent law is largely operated based off of statutes because we have this thing called the Patent Act that was passed in 1952, which codified the requirements for patentability and patents within U.S. statutory law. So we already had a lot of these requirements in case law. The Patent Act codified them into statutory law. And the patent statute, if anyone is curious about what it actually says word for word, we're going to break down a little bit sort of what the requirements are and what some of the sections are, and I'll try to kind of point out the section names as we go along. But the patent statute is chapter 35 of the U.S. Code. So if you go to chapter 35 of the U.S. Code, you will find the current statute, statutory language for patent law, which includes the language of the Patent Act, as well as some subsequent amendments to the Patent Act of 1952. So there are a couple statutory changes that I want to kind of flag at the beginning, and they're important because they create some kind of complicated frameworks within patent law and create some of the most fulsome areas for patent litigation. So first, 1995 was the General Agreement on Tariffs and Trade. This is almost always abbreviated as just the GATT in various articles that you'll read about it. And the GATT did a very simple change to the patent law framework, which had a lot of follow-on effects. So before the GATT, the patent term in the United States was 17 years from issuance, right? So once you were issued a patent, you had that patent for 17 years. And after the GATT, we now have a 20-year from filing patent term. Okay, so from initial filing, right? So once you filed your patent, you have that patent for 20 years. So there are, some cases where you have, if there's a patent that had its initial filing before 1995, and there have been a bunch of continuations, that's still under the pre-GATT framework. It was filed before 1995. After 1995, you're in the post-GATT framework, where it's 20 years from the initial filing date. The next statutory amendment that I think is important to flag at this point is the America Invents Act, which was passed in 2011. Most of it went effective in 2012, some of it in 2013. We'll talk about some of these nuances in a bit. The America Invents Act, or the AIA, as it is often referred to by patent lawyers, shifted our patent system from a first-to-invent system to a first-to-file system. So before the AIA, the question of who got a patent, if there were kind of competing inventors who were claiming the same patent, before the AIA, the question was who was the first to invent that patent and reduce it to practice. So there was a question about reduction to practice, meaning did you make it? Were you able to then sell it on the market and sort of scale it up? Did you reduce it to practice? After the AIA, it's in some ways, it's in many ways a much more simple system. Who was the first to file the patent application, regardless of who was the first to literally invent it, right? So if you invented something, I invented that same thing a couple weeks later, and I was the first to file it with the PTO, I would get that patent. I was the first to file. So the post-AIA system creates a much cleaner framework for how to define who gets the patent. But there are still a lot of cases that are under the pre-AIA framework, right? So patents that were filed before 2012 that are still being litigated. As I think I tried to impress upon you all in the first lecture, lawsuits take a long time, and like longer than you could ever imagine. So, 12 years is not an unreasonable time for a lawsuit to still be litigated. That's just kind of how this process works. And so there are still plenty of cases that are under the pre-AIA framework. So anytime that you're sitting down and reading a case and going, I'm trying to figure out what's going on here, this is a little bit confusing, ask yourself, are we pre or post GATT? Are we pre or post AIA? Because that framework is going to be important for figuring out how some of these nuances play out. So, what's a patent? A patent is a right to exclude others from making, using, selling, offering to sell, or importing the invention for 20 years after the patent was filed. That is the way current US law works after GATT. So patents, you start with the patent claim. This is the document that you would file with the PTO, the Patent and Trademark Office, and the patent claim is the piece of paper that says, here is what I have invented, and here is what it is comprised of, right? So you need to fully disclose what it is that you've invented, what it is that is comprised of the patent. Why is this really important? Well, when you have to sue someone for infringement, what is the judge or the jury in that case going to look to? What does the patent claim say, right? So the more specific you are with your patent claim and your patent claim language, the better off you're going to be able when you find the time where you need to, prosecute some patent infringement claims because you think people are stealing your invention. It's a very kind of case-specific analysis based off of what does the claim say. So, what can you patent? There are 5 requirements for patentability. We'll go through each of them one by one. The first is that you must patent something that is patentable subject matter under Section 101 of Chapter 35 of the U.S. Code. And Section 101 lists categories of patentable subject matter. The categories are, you can patent a process, a machine, a manufacturer, a composition of matter, or any improvement thereof. For lack of a better term, you can patent basically everything. Yeah.
What was the fourth one you said?
So process, machine, manufacture, composition of matter, or improvement thereof. So by and large, anything that is under the sun that is made by man. And there are a few exceptions that we'll talk about. So a process, this can be a process, an art, a method. It can include basically any new use of a known process, machine, or composition. So, that's a pretty broad one. Machines, these are, any articles with moving parts, right? Pretty broad definition there too. Composition of matter, 2 or plus substances through a chemical union or a mechanical mixture. Manufacture, this is the production process of articles, giving those things new forms, qualities, properties, or combinations. And then you can also patent new or useful improvements of existing processes, machines, manufacturers, etc. Okay. So what can't I patent, right? If patentable subject matter under Section 101 is basically everything, the question is, what is it that I am not allowed to patent? And there are a few things that you're not allowed to patent. So you cannot patent a law of nature. So something that is a fundamental fact about the universe, it is not new, you cannot patent it, right? So if Isaac Newton were around today and discovered gravity and went to the PTO and said, I would like to patent gravity, I discovered it, they would say, no, you cannot do that. That is a law of nature. That is not patentable subject matter. It is not new. It's a law of nature. It's a fundamental fact of the universe. You cannot patent products of nature or natural phenomena. And so we've talked a little bit about some examples of these. The most common is, right, gene patents, right? That's where a lot of the controversy about the products of nature or natural phenomena exception is are they, discoveries that are, have utility and are novel? Are they natural phenomena? The Supreme Court has said they are natural phenomena. You can also not patent abstract ideas, right? So things that are kind of abstract thoughts, but not physical or concrete ideas. One sort of example, you can't patent mathematical formulas. Those are not patentable. They are ideas of thought. They're not physical or concrete. And the idea of why we exclude these things from patentability is we say, okay, well, when inventors invent things, they use other things to make those inventions, right? So the building blocks, the fundamental building blocks of any other invention, right? Natural phenomena, laws of nature, right? Some of these abstract ideas of thought, these are what we use to build off of when we make other things. And so we're going to exclude those building blocks from patentability because we want people to use those things to create their own patents. Then the Alice Mayo case included another step here, which is there needs to be some inventive step, right? So there needs to be some aspect of an element or a combination of elements which is sufficient to ensure that the patent is more than just a patent on the ineligible concept itself. There needs to be some application of the invention. So that is the patentable subject matter requirement. The second requirement for patentability is the utility requirement. So we're still in Section 101. Section 101 says that patents need to be useful. What does it mean for a patent to be useful? Now, frankly, this is a pretty low bar, and there are not a lot of patents that fail the utility or the usefulness requirement. So one, your patent needs to work. So if you make a machine and the machine doesn't work, not patentable, doesn't have utility, doesn't work. So it needs to work. It needs to have some scientific basis behind what the idea is. So you cannot patent things that are like completely science fiction and plausible out there. So there are people that have tried to patent, for example, warp speed engines like you might see in Star Trek. Well, okay, these are not, they don't have utility because there's not a current scientific basis for the invention. So not a plausible invention, fails the utility test of Section 101. Additionally, there's another requirement within the utility requirement besides it needs to work, which is it needs to have some beneficial utility or social benefit. Again, this is a really, really low bar, and basically what this means is interpreted by courts is it needs to not have a social harm, okay? So it needs to not be like totally immoral. There are, to give you some examples of things that are unpatentable under the beneficial utility test, if you had like a new method of manufacturing illegal drugs, okay, the court would say, look, this doesn't have beneficial utility. It's not useful. It is socially harmful. We're not going to let you patent that. Things that are just completely immoral, right? If you had a new method of abusing animals or something, the court would say you cannot patent that. That is immoral. That's horrible. Additionally, the AIA had added a couple statutory exceptions to patentability, which basically fall under this utility requirement or, this idea of we don't want people to patent things that are socially undesirable. So the AIA says you cannot patent human organisms. Now, I think there's an open question of when they say you can't patent human organisms, Are they talking about, human cells and human genomes? Does this have some application to the gene question? The the congressperson who wrote the AIA amendment about human organisms basically in debate said it's not about that. It's about like full humans. You can't patent full humans. We just wanted to like put that in the statute. But that one's out there, and maybe is something to look into. The other kind of funny one is you cannot patent tax avoidance processes. So if you had a really new, cool, inventive idea for how to avoid taxes, sorry, you can't patent that. It's in the statute. So, our side gig, our side hustle is up, we can't patent it. That is the utility requirement. Third requirement, we're on to section 102, finally. Section 102 imposes the novelty requirement. What is novelty? So, Section 102 says that a person is entitled to a patent unless the claimed invention was patented, described in a printed publication, in public use, on sale or otherwise available to the public before the effective filing date of the claimed invention. So, when we're analyzing novelty, this is where the pre-AIA and post-AIA cases tend to matter the most, right? Because when we shifted from first to invent to first to file, we had to change this idea of novelty in prior art because, this is the kind of area where that aspect tends to matter the most. But, even under the AIA, where we have a first to file system, there's still the requirement that you need to have invented the thing that you're trying to patent, right? So we'll take the example from earlier where let's say you patent something, I saw you patent it and I stole your notebook, right? And then I made the thing and I filed a patent with the PTO. Well, I didn't actually invent that thing. Okay, so maybe I shouldn't get the patent there if I was not the inventor. So there's still a requirement on the AIA that if you're getting a patent for something, you invented it, right? So we've got a first to file system, but there's still the invention requirement, and there's still this prior art thing that can make sure that your patent gets excluded. So, what are these rules? How do they operate? So if there's an invention that's already been patented, you can't patent it. That's pretty obvious, right? If there's an invention that has been described in a printed publication, you cannot patent it. What does described in a printed publication mean? How does this most often work? Frankly, the most common way that this gets applied is foreign patent applications, right? So let's say somebody invented something in Japan and then filed a patent application for that thing in Japan, and now in the open records, there's like a printed publication of here's how this patent works. Well, if I then try to file a patent I copy it, I file a patent with the PTO, I didn't invent it, right? It's prior art because it was described in a printed publication somewhere else in a foreign patent application. You cannot patent things that are on sale or in the public use somewhere else. And this is, fairly self-explanatory. If there is something that is already being sold to the general public, we probably don't want people to start patenting it. So that's the novelty requirement number 3. We move on to section 103, the fourth requirement for patentability, which is non-obviousness. Non-obviousness. So the non-obviousness requirement says that if your invention is obvious to a person having ordinary skill in the arts when the invention is presented, then those ideas are not patentable. So who is the person having ordinary skill in the arts? Well, it's a little bit of a vague thing, but typically there's somebody who has some creative capacity. They have knowledge of how your field operates, right? So they are someone who is skilled and has some creative capacity. They're not just the average Joe. They have skill in the art, but the person having ordinary skill in the art is not an actual person. This is a legal fiction, right? So the court is sort of imagining, what does this person having ordinary skill in the art look like? How would they sort of approach this question? And so you'll often see this, once again, abbreviated as the faucita. So you'll probably read a lot of articles about patents that will refer to the faucita when it talks about questions of non-obviousness, when it talks about questions, some infringement questions. So there's a lot of questions about the faucita within patent law, and faucita is this person having ordinary skill in the art. Okay, so when we're looking at non-obviousness, this is obviously a pretty high bar. And so we're looking at, well, one question that we're asking is, okay, well, what does prior art in the field look like? What are some previous inventions? How hard was it to invent those things, right? What skill level did it take? And this is about resolving the level of ordinary skill. What is the difference between what has already been patented and what you are attempting to patent, right? So are you patenting something that's like a very, a new kind of invention that's really going to drive the field forward? Or is this kind of a minor modification of prior art? That's a question that courts look to when they're looking at the question of non-obviousness. They will also, have some secondary considerations like, okay, well, what is the commercial success of your product, right? So if I have a patent, or if I'm trying to patent something and it seems like it has benefit in the market over prior art, right, then it's probably non-obvious, right? It probably took some skill to create. And so, there are some secondary factors that courts look to when they're looking at the question of non-obviousness. The fifth requirement for patentability is disclosure and enablement, right? So disclosure and enablement. These are two sides of the same coin, but I'll sort of define them separately because I think that this is important because it speaks to the general policy rationale behind the patent system, right? Which is that we provide limited monopolies for a certain term of years for someone who invents something. And then what we get in exchange is they've told us what they invented and how they invented it, right? So after their patent expires, after 20 years, we, the society, the polity, the broader marketplace, we can now make the thing that they've made, and we can use it, and it sort of adds to the innovative processes. So you can think of the patent system in some ways as a bit of a quid pro quo, right? We're encouraging invention by providing the limited monopoly, but we're also requiring the inventor to describe their invention in such great detail that someone else can replicate that invention when the patent term is up. So disclosure, you need to provide a specification and a description of what it is that you invented, okay? So there needs to be a written description, which is clear and concise and in exact terms of what exactly you invented. And then you need to describe, once again, clear, concise, exact terms, how to make and use it. And the person who needs to be able to understand how to make and use it is who? The faucita, the person having ordinary skill in the arts. The faucita needs to be able to read the disclosure and needs to be able to go, okay, I know how to use this, right? So this is the enablement requirement. So the inventor has to disclose, they have to tell you what it is that they've invented, but they also have to tell you how do you make and use the invention in clear and concise terms so the faceta, without kind of undue experimentation or difficulty, can sort of pick up the invention after the 20-year term, and they can figure out how to make it and how to sell it on the marketplace. So those are the 5 requirements for patentability, right? We've got, sort of going backwards: disclosure and enablement, non-obviousness, novelty, utility, and patentable subject matter. I'll pause here for questions before we move on to infringement. That is.
So if, currently, if there are, patents that people owned that were under the, first to invent system, if someone else was able to prove that they invented it before them, are they still allowed to, sue over that?
So typically this is, we're almost always in a situation where that person has now patented, right, their thing.
Mm-hmm.
And so since we're 12 years past that, you probably, it would be very difficult, I imagine, to sue for, hey, I actually, this happened 15 years ago and I actually invented it first. You may have cases that are still being litigated where you've got sort of what I described as the sort of semi-simultaneous invention problem, right? Where you've invented something and then a couple weeks later I invented it and a couple weeks later someone else invented it. And so we've all, we've got some simultaneous invention happening and we're in the process of litigating who gets the patent, right? So the patent's not already sort of filed and issued, but we're litigating the question of who was the first to invent. There might still be some of those cases. So the theoretical answer to your question is like, yes, who was first to invent is still a litigatable question. I think that there would be, some, probably like, hey, this is too late problems going on if you said, hey, I was first to invent the iPhone. That might be a tough sell, at least in the modern environment. Yeah.
In regards to the beneficial utility standard,
Yeah.
if the federal government has deemed something illegal, but can that the states, for example, have deemed it legal, let's say in the case of marijuana,
Mm-hmm.
does that mean that is unpatentable because it's not beneficial utility?
Well, so cannabis itself, unpatentable as a product of nature. A process relating to cannabis, I can imagine, would have questions regarding whether it met beneficial utility, because we're typically, when we're talking about patent law, we are talking about federal law, right? So this is a federal statute, and as a practical matter, when we're talking about federal statutes and federal questions, we're usually in federal court, either because the plaintiff has put it there, but often because the defendant wants to be in federal court for some reasons that are a little complicated, but just take my word for it, the defendant wants to be in federal court. So when we're in federal court, they're looking at what federal law says, and because federal law says marijuana is a Schedule II drug, they'll probably say, yeah, this is Congress has said it's immoral, right? There's a statute that's passed that schedules cannabis alongside sort of other, fairly dangerous drugs. And so, regardless of what, state law says or, whatever sort of conventional questions of what is or is not immoral says, federal law has said, cannabis consumption, illegal, immoral. So I imagine patents that are, related to processes or machines or sort of, cannabis adjacent or cannabis adjacent inventions might have questions regarding beneficial utility. Other questions about patentability? All right, let's move on to infringement. So once again, patents grant the right to exclude others from making, using, selling, offering to sell, or importing an invention for 20 years from the time the application was filed. So patents are a negative right. They tell people what you cannot do. So they exclude others from making, using, selling, offering to sell, importing an invention. So anyone who does that is subject to infringement. And, in some cases, these are sort of very clear, what we call literal infringement, meaning that there is language in the patent claim that says, here's what I have made, and then someone has sold or invented a product or a process that falls sort of directly within the language of the claim, okay? And so we're looking very closely at what the claim says when we're looking at direct or literal infringement. And when that happens, what happens? Well, the patent holder then gets to sue the infringing party in court. And we've talked a little bit about how that works at the earlier lecture. There are times where there can be cases regarding indirect or third-party infringement. And what do I mean by this? So there can be liability to someone who actively induces infringement for a patent. Right, let's say, when we're having this Apple-Samsung disagreement, like, Apple made the iPhone and, I called up Samsung and I was like, hey, like, I bet you could get away with selling a phone that looked a lot like the iPhone, but was a little different, right? If I actively induced the infringement, then I can also be sued. Okay, so any party who like encourages or induces or maybe provides some financial assistance, they could be liable for infringement. The other piece of third-party infringement is contributory infringement. And so this is not just active inducement, but I've helped someone infringe on a patent. So maybe I've, sold or offered to sell a component of a patented invention and said, you can use this in your process. I've contributed to infringement. I haven't done the literal infringing, but, I've helped someone else infringe it. I can also be liable for infringement in that world. There's also this idea which is called the doctrine of equivalence. And the doctrine of equivalence is the idea that if the functions of the patent claim are the same, then that is infringement. And now, you might think that this sort of sounds obvious, but again, when we're dealing with lawyers and judges, sometimes we take things a little bit overly literal, right? And so you've got this patent claim, and it's got a written description of the invention. And so at times, infringers have sort of tried to play some word games with this patent claim. And it's like, okay, well, we're not really that word, and we're like not that other word. And so we're not literal infringement within the four walls of the claim because we're doing a T debate, right? And we don't really meet this T debate. And so the doctrine of equivalence is like, they're like, no, this is like a reasonability standard. Like, no, we're not playing word games. This is a question of the function of the invention, right? So even if you've, changed the invention in some sort of minute way that is negligible on the effect, if you've got the same function as the claim, if you've done the same thing as what the patent claim is, you've still infringed on the patent. That is the doctrine of equivalence. So that is the question of infringement. We'll talk a little bit about the question of defenses. So there are a few defenses of infringement. So one, common defense to infringement is that the patent was invalid because it did not meet the 5 requirements for patentability that we went over at the first part of this lecture. That's almost always being raised in an infringement lawsuit, right? So if somebody's infringing on a patent, I guarantee you the defendant is going to say, wait, you never should have gotten that patent in the first place. This was an invalid patent. It was obvious, right? It was not patentable subject matter. That is always, always, always being raised, is the validity of the patent. Another defense is this question of inequitable conduct. So maybe the patent holder did something untoward. So maybe they withheld or they misrepresented information in the PTO. They tried to deceive the PTO for some reason, right? So they don't really come to this patent process with clean hands. That is a defense to infringement. Yeah.
How does that differ from saying that the patent was invalid?
Because it is about the literal actions of the patent holder rather than the legal requirements of patentability. So validity is purely just like, do you meet the legal requirements for patentability, those 5 requirements that we talked about? Like, that's the question of validity. And equitable conduct is, how did the patent holder act, right? So it's not solely a question of validity, it's how did the patent holder act. The other, and this is pretty common, is this idea of experimental use. So, invention, usually says, look, if you want to try to use something sort of in private or personal, personal to yourself, experimentally during the statutory period, typically that's not considered infringement, right? So if I'm just sort of in my basement, trying to invent the iPhone because I'm trying to figure out how this stuff works, typically that's okay. Experimental use, private, personal, you're not selling it, that's a defense to infringement, because when the patent holder is filing an infringement lawsuit, they're saying our market position has been harmed, right? We have lost money as a result of this infringement. That's the basis of the lawsuit, right? So experimental use, another defense. I'm now going to talk about 2 concepts that I'm sure we're all familiar with, at least in some degree now. So latches and prosecution latches. I will start with the equitable defense of latches because I think that this provides some context for what's going on. So, what is the defense of latches? So, latches says you were too late in filing this lawsuit, therefore, you should lose this lawsuit. You were too late in filing the lawsuit, therefore, you should lose this lawsuit. So the most common application of the doctrine, the defense of latches, that I remember thinking about is, so in 2020, right after the election, happened, former President Trump filed a series of lawsuits about how the election was conducted and about some of the rule changes that state electoral boards implemented as a result of COVID-19. And so former President Trump's argument in those lawsuits was, hey, these COVID rule changes were against the law. They should not have been implemented. And, they harmed me. They meant I lost the election and the election should be thrown out as a result. Well, what happened in a lot of those lawsuits is Trump lost on latches. So the Biden lawyers said it is too late to file this lawsuit because you waited until after the election happened to file the lawsuit. You should have filed the lawsuits when the law changed, right? When you knew the harm was about to happen. You waited, until sort of we've had an election and we figured out who the next president will be to file this lawsuit. You waited too long. So you are barred by the equitable doctrine of latches from filing this lawsuit. And that was a winning argument in some of those state cases. That is the equitable defense of latches. What is prosecution latches? Prosecution latches is the unreasonable delay in patent application. Okay, so not unreasonable delay in filing suit, that's equitable latches. Prosecution latches, unreasonable delay in application. So why is this particularly relevant? Well, as we know, in the pre-GATT framework, it used to be the case before 1995 that your patent lasted 17 years from issuance. And so what people would do is they would file what's called submarine patents. That was what it was referred to, where they would file an initial patent application and then they would file a bunch of continuing applications. And they'd say, oh, well, we're changing this a little bit and we're adding this, subtracting that. And they would file all these continuing applications and sort of like make it to where it was years and years and years and years until their 17-year clock started, right? So they'd try to sort of run out the clock before their 17-year clock started so they can keep their monopoly on the patent for as long as possible. And so the doctrine of prosecution latches was applied to say, no, you cannot do that. You cannot unreasonably delay the issuance of your patent under the pre-GATT framework because that would be horrible, right? And now there are some apps that have been put out at this camp about the application of the prosecution latches doctrine to the post-GATS framework, right? Where it's 20 years from filing date, you might still have some continuing applications that, claim priority date to the prior filing date. And so prosecution latches simply is the unreasonable delay in patent application. Equitable latches, unreasonable delay in filing a lawsuit. Prosecution latches, unreasonable delay in application. I will stop at the defense's question to answer any questions that you all might have, either about infringement itself or about defenses to infringement. And then after that, we'll talk about remedies. Thaddeus.
What about the GATT framework made the prosecution latches like less relevant?
Because you couldn't run out you couldn't submarine patent because it's not about issuance, it's about the patent filing date. So yeah. So it's about the initial filing date under the post-GATT framework, which meant it was just much harder for patent holders who are trying to just like run out the clock and like, wait before the 17-year clock started, because once they filed, the 20-year clock starts. That's the rule.
So how do the continuing applications work under the GATT framework?
So the continuing applications, typically the initial application or the initial filing starts the clock. So your 20-year clock starts, and then continuing applications will allow you to make minor modifications to the patent, right? So if you're like, okay, we're changing this process and we're gonna, change this part to that part, change this process for making it to this, right? You can do that and you can still be covered by the initial patent, but the clock starts at the initial filing.
And can you file continuing applications for all 20 years of the patents?
I believe so. I don't think you're ever barred from, like, if you're within the statutory period, barred from making a continuing application. Other questions about that? All right. We'll talk about remedies. So the most common remedy is money damages. Okay? You've infringed on my patent. What do I want? I want money. How much money do I get? Section 284 of which chapter? 35? Yep. Section 284 says I get money adequate to compensate for infringement in no event less than what a reasonable royalty for the use made by the invention is, with interest and costs as fixed by the court. Okay? So I get money adequate to compensate for infringement, but never less than what a reasonable royalty would be for use of the invention, plus interest, plus costs. So how do I figure out what damages are that are adequate to compensate for infringement? Well, so the primary question here is lost profits, right? So I've made an invention and I'm selling it. That's how I'm making money. It's how I'm putting a roof over my head. And you have infringed on my invention. You have infringed on my patent, and you are also selling that invention. And so maybe I have lost some demand for my product. Less people are buying my invention because they're buying your infringing, fraudulent invention that is infringing on my patent, right? So we're going to try to figure out how much money did I lose as a result of your infringement activities, and that's how I'm going to figure out how much money I should get for money damages. And sometimes this can work in complicated ways, right? So how much market share do you have? Has the price eroded, right? Because the market's now been flooded. And so we're looking at a lot of different factors to figure out how much money did I lose as a result of the infringement. And then the requirement is that it cannot be less than a reasonable royalty, right? So, you might have some testimony about, okay, if I were to license this patent to you and you were to use the patent on a royalty arrangement, how much would you have had to pay me? That at the bare minimum, you owe me that, right? If we're having a tough time figuring out exactly how much money I lost as a result from the patent, as a result from the infringement, then we're at the very least going to try to figure out sort of what happened here and what would a reasonable royalty have been. All right, so money damages is one remedy. The other remedy that's important to us is injunctions. Yes, we want an injunction. We want an injunction. We would like for you to stop selling the infringing product. We are upset that we are not getting an injunction, okay? And there is a 4-factor test for injunctions. And the 4-factor test for injunctions in the context of patent law is actually, pretty similar to the test for an injunction for like basically anything else. So the test is as follows. 1, you need to prove that there will be irreparable injury if you are not granted the injunction, okay? So if I don't get this injunction, if I don't get this court order that you stop selling the infringing product, I'm going to suffer, harm that cannot be repaired by money damages, right? No adequate remedies at law, right? This is a somewhat similar requirement. When it talks about remedies of law are money damages. So in the old days, and I know I've used these words a little bit without some context, but law and equity. So in the old days, you would sue someone at law when you were trying to get money damages, and there would be separate courts. There were courts of law. You go to a court of law if you were trying to get money damages. And then if you were trying to get an injunction, you would go to a court of equity. They were different, literally different courts that you would go to. There are very few states that still preserve this distinction in any real form. Delaware does kind of a little bit. So there's been a merger between questions of law and equity, but usually when I'm talking about remedies at law, that's money damages. Remedies at equity or equitable, equity refers to trying to get an injunction, trying to get a court order to stop doing something. So no adequate remedies at law means money damages does not solve the harm, right? We need to get an injunction to solve this problem. Then the court will look to the balance of the hardships. So how difficult would it be for the defendant, for the accused infringer to like wholesale, for their business? Would they like go bankrupt if they had to stop selling the infringing products? The court's gonna view that question when they're looking at whether to grant an injunction. And then they're going to look to the question of the public interest, right? So what would the market look like? What would kind of the social factors be, and whether they grant an injunction. So those are the 4 factors that they look at for granting an injunction. And injunctions in patent law have become a little bit complicated because there's the eBay case, and there are different opinions in the eBay case that describe kind of different factors and tests for how do we analyze those 4 factors, right? Because they're kind of vague and vacuous just in the statute. And so there are actually, I mean, different justices have kind of adopted different theories for how to view the test and how to look at injunctions. I'll now stop at this point for questions about any of this stuff. So remedies, infringement, patentability, any questions you might have. Yeah.
What were the 4 different points of the 4 factors again? It was
So 1, irreparable injury. 2, no adequate remedy at law. 3, balance of the hardships. 4, public interest. Those are the 4 factors.